Major breaking news involving so-called assault weapons, magazines, and AR-15 bans. The United States Court of Appeals for the Third Circuit has just made a huge ruling, in my view, signaling support for the Second Amendment. You're not going to want to miss this breaking news. This is a big deal, folks. Let's break it down. Hey, folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, this is a very big deal, folks. Almost unprecedented. With what just happened today, with the so-called assault weapon ban, the magazine ban, the AR-15 ban in the state of New Jersey. As you may recall, there's a series of lawsuits in New Jersey challenging New Jersey's bans on so-called large-capacity magazines and AR-15s and semi-automatic rifles, among other things. A lower court judge found only that Colt-branded, that's right, the company Colt-branded AR-15s are protected arms under the Second Amendment, and nothing else. This went up on an appeal. It was argued in the United States Court of Appeals for the Third Circuit, which is the circuit that covers Delaware, Pennsylvania, and yes, indeed, New Jersey. It was argued in early July. Multiple cases consolidated, including the Cheeseman case and the Association of New Jersey Rifle and Pistol Clubs against the Attorney General of New Jersey. These cases are consolidated. And here's what's very interesting. This is a bad panel, as I explained. Terrible panel. We were undeniably going to lose that panel 2-1. There was going to be a finding that AR-15, semi-automatic rifles, and magazines were not protected arms under the Second Amendment. That was undeniably going to be the result of that panel decision that was argued on July 1st of 2025. So what just occurred that is fantastic news? Out of the blue, a sua sponte order, which means the court did it on its own initiative without a request from any party. The United States Court of Appeals for the Third Circuit in its entirety has just ordered that this case, or these consolidated cases, will now be re-argued en banc, which means that the entire Third Circuit Court of Appeals is going to rehear argument, the same argument that was heard on July 1st. This case will be reheard before there was even a panel decision issued. So let me tell you what I'm almost certain occurred here. You had an oral argument over AR-15s, semi-automatic rifles, and large-capacity magazines, and whether or not they're protected arms under the Second Amendment. You had that oral argument in front of a 3-judge panel on July 1st, 2025. That panel, as I explained at the time, was a terrible panel for the Second Amendment. We were undeniably going to lose that 2-1. What almost certainly happened was a draft opinion explaining that these arms are not protected arms under the Second Amendment was circulated to every judge in the United States Court of Appeals for the Third Circuit, which is protocol. Meaning when a panel drafts an opinion on a topic, they circulate the draft opinion internally to every judge in the U.S. Court of Appeals for the Third Circuit. This must have occurred, and it must have been a decision. This is my prediction. This was a decision that said these arms are not protected under the Second Amendment. What then happened almost certainly is that the majority of the judges on the U.S. Court of Appeals for the Third Circuit, including Chief Judge Thomas Hardiman, this is my guess. I don't have any inside information, but I'm speculating, but I'm pretty good at this. The Third Circuit judges took a look at the panel decision and said, this is clearly wrong. This panel is going to throw the Second Amendment under the bus, and that is inconsistent with Supreme Court precedent and the text of the Second Amendment. And as a consequence, the Third Circuit decided to vote internally whether or not to allow that panel decision to be released, or whether or not they would hear the case, all the judges, all the active judges sitting in the Third Circuit, whether or not they would hear the case en banc, which means all the active judges would hear the case, plus the single senior court judge or the senior judge that was on the panel. And it's pretty clear that the Third Circuit voted to hear this case en banc because they've just issued the sua sponte order ordering that the clerk of the court to list this case, these consolidated cases of Cheeseman and the Association of New Jersey Rifle and Pistol Association for oral argument in Philadelphia, Pennsylvania, on October 15th, 2025. So this is fantastic news. And this is the kind of inside information you turn to the Four Boxes Diner for. Now, I'm going to say one thing. Listen to me very carefully, folks. The breakdown of this court is somewhere, now that Emile Beauvais is now a judge on the Third Circuit, you now have a slight lead with Republican appointees over, outmeasuring or outnumbering the Democratic appointees. It's going to be something like 7-6 or so. But you also have one senior judge, Judge Smith, who may be good on the Second Amendment. So maybe right now, if you're trying to count noses, you might have a 7-6 or an 8-6 victory, presumably, in favor of the Second Amendment right to keep and bear arms. So this is mission critical, folks, and I think everyone in the Second Amendment community needs to work hard at what I'm about to say. This is not a joke, folks. It is mission critical, in my view, that the pending nomination of future judge, we hope, Jen Mascott, to the Third Circuit Court of Appeals be expedited and confirmed by the U.S. Senate in time for her to be able to sit and hear argument on October 15th, 2025. It's important the judge presumed to be Judge Jen Mascott. She's not a judge right now, but that Jennifer Mascott be confirmed by the United States Senate by October 15th, 2025. That would be very important because that would give the Third Circuit another Trump appointee on that court to hear this case en banc involving the fundamental right to keep and bear arms and AR-15, semi-automatic rifles, and so-called large capacity magazines. Now, here's the thing. This is likely going to result in a Court of Appeals victory that's going to find that AR-15 semi-automatic rifles and so-called large capacity magazines are protected arms under the Second Amendment. That is probably the outcome based upon everything that's just occurred here. Because we know it was a terrible panel on July 1st, and if they're just going to issue an anti-Second Amendment ruling, the Third Circuit, and if the Third Circuit in its entirety was okay with it, they would have just let the Third Circuit three-judge panel issue their terrible anti-gun ruling, their terrible anti-Second Amendment ruling, and let it go and done nothing about it. Because remember, it takes up a lot of time and resources and headaches for an entire Court of Appeals to hear a case en banc. It's a lot of work. It sucks up a lot of court resources, and you don't generally do it because en banc review in the Third Circuit is really extraordinary. And you don't need to do en banc review over a three-judge panel unless the en banc court decides that the three-judge panel got it wrong. And because we know that three-judge panel was terrible on the Second Amendment, odds are it circulated an anti-gun opinion within the Third Circuit, and the entirety of the Third Circuit saw this, and they would not even allow it to be issued publicly. They just took the case and en banced it internally and just sua sponte on its own initiative came out and said, we're going to hear this case with the entire Third Circuit because the three-judge panel was going to screw up this opinion involving the Second Amendment, and we don't want that to stand. So now the question is going to be is, presuming that I am correct, and this Third Circuit en banc group is going to rule in favor of the Second Amendment, that's going to give rise to a circuit split because you're going to have a lot of courts out there that have said in the Ninth Circuit and the Seventh Circuit and whatnot that these various arms are not protected arms under the Second Amendment. But then you're going to have a Third Circuit en banc decision over New Jersey that's going to say that they are protected arms. That is going to give rise to a circuit split, folks. And as I've explained to you before, I think I even wrote about this, I can't remember if it's in Bloomberg Law or in the National Pulse, I forgot where I published this a few months ago. As you know, the New Jersey situation with the Third Circuit is particularly important for the Second Amendment because it's one of those, it's like really the only instance in America where you have a terrible anti-gun court that has all the nonsensical anti-gun laws. That would be the state of New Jersey, overseen by a court of appeals that is at least sympathetic to, friendly to, and respectful of our Second Amendment right to keep and bear arms, which the Supreme Court has said is a fundamental right. That is a rare situation because in most instances, the good gun jurisdictions like Texas and Louisiana, they don't have a bunch of crazy anti-gun laws. So the U.S. Court of Appeals for the Fifth Circuit, which does respect the Second Amendment, doesn't have a chance to rule on a so-called assault weapon case because there are no assault weapon ban laws in Louisiana, in Mississippi, in Texas, for the Fifth Circuit to knock out and create a circuit split. But here will be a particular instance where if the Third Circuit does what I'm now predicting they're going to do, which is to say these are protected arms under the Second Amendment, you are now going to create a circuit split with the other courts of appeals. And that is a fantastic phenomenon because, as you know, Justice Brett Kavanaugh just a couple months ago said in his concurring opinion in the denial of cert in the Snope AR-15 ban case out of Maryland, Justice Kavanaugh specifically said that he expects that the U.S. Supreme Court will take an AR-15 ban case in the next term or two. And if the Third Circuit comes out in our favor, that will create the circuit split. And now, even by traditional measures of whether or not the Supreme Court should hear a case, meaning is there a circuit split on a critical constitutional question, you now have the circuit split, which even a justice like Justice John Roberts will be cognizant of, which is fantastic news for our right to keep and bear arms. And this goes back to my point that I said at the Gun Owners of America Goals event just a few weeks ago, that we are going to have a Second Amendment case involving AR-15s in the next 12 to 18 months. And I suspect we're going to win it and win it big. But again, the history of the future has yet to be written. So there you have it, folks. Huge news involving the Second Amendment out of New Jersey and the Third Circuit Court of Appeals. We will be covering that October 15th oral argument in Philadelphia when the time comes. But in the meantime, make sure you follow me on X at 4Boxes Diner. And don't forget to follow me both on YouTube and on Rumble. And I look forward to talking to all of you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.